Third-degree arson sounds technical, but let's be clear, this is a felony fire-setting case. We're not talking about a mistake with a grill. This is a building burned to the ground, and sentencing is where reality hits.
Mr. Taylor is before the court along with his attorney, Ms. Tiffany Hughes. People are here and represented by their elected prosecutor, Mr. Scott Kerner. Agent Rolfe is present from the Michigan Department of Corrections. Mr. Taylor was before the court last on the plea date was November 13th of the year 2025. And on that date, Mr. Taylor pled guilty to arson in the third degree. As a result of that plea-based conviction, the Michigan Department of Corrections did prepare a pre-sentence investigation report and an SIR, that stands for Sentencing Information Report, and distributed the same to the parties and to the court. Mr. Taylor, would you raise your right hand with me? Do you promise that you will tell the truth, the whole truth, nothing but the truth, so help you God?
Yes, Your Honor.
And you may put your hand down. Mr. Taylor, did you get a chance to read the pre-sentence investigation report that the court just referenced? Yeah, let me finish my question, please. It's okay. I talk fast, so you want to answer fast, but I get it. Did you get a chance to read that?
Yes, Your Honor, several dozen times.
Yes, okay. And dear attorney, Ms. Hughes, did she make herself available to you to answer any questions you might have or address any concerns you may have about the contents of that report?
Yes, Your Honor.
And as you read through that report, Mr. Taylor, did you find the facts that are contained within the agent's description of the offense and the narrative, was that all true and accurate to you?
I know it says on there I did lack accountability. I do take full accountability for it.
Where you said you didn't really do it, you just pled because you didn't want to get in more trouble?
Yes, I was under stress that day and just wasn't in the right mindset, but I do take full accountability.
So it's interesting to me that you pled guilty under oath that you did start the building on fire, but then in your plea you said you didn't, you just did it because you didn't want to, for whatever reason you didn't. Now you're saying you did do it.
Yes, Your Honor.
Full circle, right?
Yes, Your Honor.
All right, good. Ms. Hughes, you get a chance to review the PSIR?
Yes.
All right, and is there anything in that report that you would like changed?
Yes, the sentencing date.
And Agent Rolfe, maybe we can fix the dates. It's unlikely that
Yes, Your Honor.
maybe, I mean, there are some children born addicted in utero, but maybe not this case. Good. Thank you, Ms. Hughes. Those changes will be made. Mr. Kerner, you have a chance to review the pre-sentence investigation report?
I have.
Any changes you'd like to see made to the body of that report?
No, Your Honor.
Mr. Kerner, do you have any scoring challenges?
I do not.
Very good, then. Do you have a victim who wishes to address the court this morning?
I do not.
Thank you. Ms. Hughes, elocution.
Yes. Your Honor, just speaking with Mr. Taylor, he has just been forthcoming and just admitted his responsibility and just taking full accountability. He does have a plan and he does have support for when he gets out. He has a job that he can work with his friend doing mobile mechanic work. And he appears to want to go back to school. And also his most important job is being a father to his children, Your Honor. So I accept the court fashion a sense where he can get out and get on a positive path and take care of his responsibilities outside of the jail.
Thank you, Ms. Hughes. Mr. Kerner, for the people.
Thank you, Your Honor. I'm not entirely sure that he is being accountable, but one thing is for sure, he hasn't learned his lesson. I'd ask the court to fashion a sentence that focuses on punishment and deterrence, Your Honor.
Thank you, Mr. Kerner. Mr. Taylor, this is your opportunity to address the court. What would you like to say?
I know my actions at November Day were not the best, and to my sons, Dylan and I love you, hope to see you soon. And then to my son, Denver, and my daughter, Ainsley, I know my mistake put you guys in the situation that they're currently in. And just know Dad loves you and misses you, and I plan to get to you guys soon.
Are you giving me a message to give to your children?
No, I'm just...
Why are you talking to your children through me?
I'm just addressing it.
Oh, okay, if that's what it's your time. I guess you can say what you like, Mr. Taylor.
And I sit in that cell every day thinking about my actions that day, and I know there were poor choices. I regret the choices. And I sit in that cell also reading the PSIR, and I do believe it is a fair recommendation on the PSI, and I do believe it's a fair report. But I do take full accountability.
When you burned the field down a couple of years ago, you said the same thing, that you took full accountability. What's going on with you? Why do you like to burn things?
It's just, I was seeing CMH too, and I don't know if it could be something mental.
You know, in this case, and it's a big deal. The commercial building and the vacant commercial building, thankfully vacant, took fire. Extensive fire damage throughout the interior of the structure. heavier mass consumption towards the north half of the building. Firefighters had to force entry to get in there and make sure nobody was in there. Roof system consumed and collapsed, and you just totally tore that building apart. Thankfully, nobody was hurt.
I am thankful for that as well, Your Honor.
And then interestingly, the building next door was burned, and you were there videotaping it. Remember that?
Yes.
It was very dangerous business. And then it looks like you used an accelerant, used gasoline to get it going. Well, in any event, your guidelines are scored 0 to 17, stat max of 120. The sentencing guidelines are advisory, but the court, Mr. Taylor, finds that they are scored accurately. The guidelines are a recommendation from our legislature, and the court finds that in this case, Mr. Taylor, the recommendation is not proportional to the circumstances of this case. The guidelines consider patterns of convictions generally, but they don't always look at the nature of specific convictions, which can be relevant at sentencing. Here, Mr. Taylor, you were convicted of burning, thankfully, an empty commercial building. That was on November, you burned it on November 7th of the year 2022. But while that case was being investigated, you burned the grass field that we talked about on July 5th of the year 2023. That case resulted in a conviction for attempted fourth-degree arson. The court gave you no upfront jail, just a term of probation. Your performance on probation was far from satisfactory, and you did not comply with a number of the court's orders. That persuades the court, Mr. Taylor, that imposing a probationary sentence in this case, well, it'll be futile. The court is also troubled by the timing of the two events. Even though the convictions entered at different times, the crimes were committed less than 1 year apart. 2 arsons in less than a year gives the court great concern in terms of public safety. Now, there are allegations of other fires that were set in the area, and there's allegations that you wrote messages on a wall in a bathroom that more fires are going to be set, and I did it, and watch out, Venice. I'm not punishing you for that because they're not before the court. But 2 arsons in less than a year is pretty significant to the court, and it does cause concern. And at the plea, just as in the last one, you described it as a stupid mistake, and that's interesting because you're consistent in your analysis of what had happened in both cases. And we did cover where you told the agent that you didn't have anything to do with this. You only took a plea to avoid trial, and I'm glad that you came around on that, but it is clear to the court that you really don't have a lot of insight into your criminal activity. Combined with your dismal performance on probation, Mr. Taylor, that persuades the court that rehabilitation,
That pause right there, that's credibility wobbling. Judges hate inconsistency. Plead guilty under oath, deny it later, then circle back again. Accountability matters more than apologies. Quick breakdown. Sentencing guidelines suggest a range, but they're advisory, not binding. The judge can legally go higher if public safety or deterrence demands it.
Unlikely outcome for you, particularly while you're still in the community. To the extent that any rehabilitation is possible, it will need to occur as part of a prolonged period of separation from society. As the court scored the guidelines, the legislative recommendation has essentially 2 components. First, the court imposes an intermediate sanction, which basically means anything other than incarceration. As already discussed, the court finds that intermediate sanctions are ill-suited to the facts of this case, as it's unlikely that you would comply with any orders of probation. Second, that any term of incarceration be limited to 17 months of incarceration. The court finds that that period, Mr. Taylor, is insufficient to address the needs of public safety and specific deterrence. In this case, you lighting things on fire. The court finds that it can best accomplish its objectives through a 1-cell shift in the guidelines. That produces a minimum range with 23 months at the high end. The court does find, Mr. Taylor, that range more proportional to the facts of this case, and you, Mr. Taylor, as the offendant. as the offender. The court would depart to reach its chosen sentence, even if the guidelines are scored differently or even in the presence of only one of these factors. That all said, you have some financial obligations. Mr. Kerner, what's the status of restitution? The court's going to reserve it. State costs, $136. Crime victims assessment, $130. Court costs, $961. Restitution reserved. You'll receive 136 days of jail credit. But as to incarceration, Mr. Taylor, you will serve a minimum of 23 months in the Michigan Department of Corrections, not to exceed 120 months. You do have some appellate rights. Mr. Schmidt will approach with those rights. What I'd like you to do, sir, is please initial the form acknowledging that you received them. If you'd like court-appointed counsel to assist you with counsel, to assist you with counsel, you got 42 days from today's date to make that request. Best of luck to you, Mr. Taylor.
One last thing. Is there, I know his sentence is 23 months, but is SAI a consideration when he goes in, or is that just something for a later date?
What happens shortly after somebody makes their way to the Michigan Department of Corrections, if he qualifies, then the Department of Corrections will send a request to the court whether or not it would consider a particular offender eligible or suitable for SAI, and I'll make that decision when it comes through. It's a fair question. All right, good luck, Mr. Taylor. I hope you get it worked out. Did we have 143 on credit? If I didn't say that, that's the credit.
Yes, I believe we did.
Mr. Wiles is before the court along with his attorney, Mr. Patrick Allen. The people are here and represented by their elected prosecutor, Mr. Scott Kerner. Agent Rolfe is present at council table from the Michigan Department of Corrections. Mr. Wiles was before the court on November 13th of the year 2025 and pled guilty to possession of methamphetamine. As a result of that plea-based conviction, the Michigan Department of Corrections did prepare a pre-sentence investigation report distributed to the parties and to the court, along with the sentencing information report. But before we get to that, we did meet on December 19th of the year 2025 at our first attempt at sentencing, but Mr. Allen had an objection regarding the 10-year gap. The court adjourned, allowed for some briefing. Mr. Allen, I never got the briefing. Are you waiving the argument?
Judge, I'm not going to waive the argument. I'm just going to object for the record. I've done a lot of research on this case, and I don't know many trial courts that are in the business of creating new law. I think the right card case is, puts the kibosh on any type of argument I would have. I am encouraged because through my investigation, I see our legislature has booted up a commission, and they're going to be tackling a lot of sentencing issues. I think in the court there, this Court of Appeals is essentially the understanding of what the guidelines were at the time of the plea were so different than what they turned out to be at the time of sentencing that, in essence, in the George case, the Court of Appeals just allowed the withdrawal of the plea in the interest of justice. But my argument, I think, falls way short. It's more of an argument that's going to be geared towards allocution in terms of how the court sentences as opposed to challenging the guidelines.
Do I need to rule on the 10-year gap rule? Are you making that objection? If I'm prepared to rule on it, I just didn't get any briefing.
No, I'm not, no, I'm not going to raise the 10-year gap because the right card case tells me that's, I'm barking up a tree.
That's 216 Mishap 186, 1996.
Right.
Just making sure we're on the same page. Mr. Wiles, would you raise your right hand, please? The best that you can. Do you promise that you will tell the truth, the whole truth, nothing but the truth, so help you God?
Yes.
Thank you. Mr. Wiles, you get a chance to review the pre-sentence investigation report?
Yeah.
Your attorney, Mr. Allen, did he make himself available to you to answer any questions you might have or address any concerns you may have about the contents of that report?
Yes.
As you read through it, did you find it truthful and accurate?
Yeah.
Mr. Kerner, have you had a chance to review the pre-sentence investigation report?
I have.
Any changes you'd like to see made to the body of the report?
No, Your Honor.
Do you have any scoring challenges, Mr. Kerner?
No, Your Honor.
Mr. Allen, do you have any scoring challenges?
I don't, I guess I would just argue that the guidelines should be scored 0 to 6 months. But I'm going to just object for the record as the way they are scored. I think if the 10-year gap doesn't come into play, which case law tells me it doesn't, I had the guidelines scored similar to the way probation did. And I'll address that further in allocution. But just for the record, I'm just objecting to secure my client's right if he should choose to appeal this down the road.
PRV 15.
Not a terribly complicated case in terms of why we're here. Ask the court to file the recommendation, place my client on probation. I think he's learned a lesson and maybe his memory's been triggered. Look, when you have addiction issues, they're lifelong. There is no one beer for Mr. Watts. There's nothing. I think he's, either come to understand that now or maybe has forgotten it because, he's put I'm looking at his track record, Your Honor, and it's, I think, almost 20 years ago. I'm sitting with my client, and at one point in time, I'm agreeing with the prosecutor that the guidelines they came up, 0 to 17, seemed correct. More conversations with my client, and I was, where the probation department is at, 5 to 23 months. More conversations with my client tells me he hasn't been in trouble in like, 15 years. And then, the 10-year gap comes into play. I mean, I'm looking at his record, and it looks like since 2005, he's had some driving while license suspended and a failure to display. Otherwise, my client's guidelines would be at 0 to 6 months. It's maddening that I've been in this for a long time, and I just cannot give my client an accurate gauge of what he's looking at. It's no fault to anyone in here, and that's why I was comforted that our legislature is going to be tackling this issue. I'm comforted sometimes, that the Court of Appeals understands that this is a problem.
This is the turning point. One fire might be a lapse. 2 fires in under a year? That's a pattern, and patterns scare judges. And just like that, case 1 ends. Prison time imposed. But the courtroom doesn't reset. Case 2 is walking in, and the tone is about to get even heavier.
The court does a very good job at taking pleas bulletproof for the most part. And the fact that we have to go over the guideline and explain that it's an estimate, it's akin to throwing a dart. And I get frustrated as an attorney that I'm coming up with 3 numbers, including and I imagine on the prosecutor's end, it's frustrating for them too, because I know they fashion agreements geared on guidelines.
But Mr. Allen, you knew on the plea date, the estimated guideline range, you knew it was 0 to 17.
That I think it just shows my point. I didn't know. I understand that it's an estimate, but it's almost like I wish we didn't even talk about guidelines, because essentially it just sets my client up.
I'm not understanding it. The guidelines are estimated, although they're 5 to 23 today, they're estimated as 0 to 17. Aren't they within the range of accepted principles? And when you talk to your client, I mean, you got the plea sheet ahead of time and he signed it acknowledging the estimate is 0 to 17.
Right. But I have to explain to them that number doesn't mean nothing. How oftentimes in this court alone, along with my history, that guidelines are changed. I haven't kept track, but, they're changed a lot. And so I understand the estimate, and I think that's the issue is and this court knows, and that's why this court takes great care when it does a plea to make sure that that's just an estimate. And it's frustrating that
the court isn't required to do that. The court does that as a service.
Right. Most certainly. But I understand it in terms of, having an accurate plea.
I don't understand your point, because he knew that Department of Corrections was on the table when he entered his plea, because he signed the plea sheet that says the estimated guidelines are 0 to 17.
That's not, I guess, my point. My point is that, there's a difference between 0 to 6 guidelines, 0 to 17 guidelines, and 5 to 23 guidelines.
I don't know where 0 to 6 ever would come into play.
Well, if the 10-year gap applied, that's what his guidelines would be, 0 to 6 months.
But, it didn't.
Yeah, that's what I understand. I'm looking at his file, and the last time he had any type of felony controlled substance issues was back in 2005.
The last time he was convicted.
Well, I guess the court takes a more cynical view than I do, but that's okay. I understand that as far as it goes. But in the end, it's just very frustrating that, I can't adequately nail down that number. And so, in part of my allocution is that to circle back around, I would ask the court to follow the recommendation, put him on probation. I've had a lot of talks with Mr. Wiles. He knows how to do this. and he will do it. He wants to be a better man for his children, and he needs to be a better man.
Yeah.
I appreciate the advocacy, Mr. Allen. I do. Mr. Kerner.
Thank you. I also appreciate Mr. Allen's advocacy. I'd ask the court fashion a sentence that focuses on punishment, deterrence, and rehabilitation. There is a long-standing history of drug use in this case, Your Honor.
Thank you, Mr. Kerner. Mr. Wiles, and this is your opportunity to address the court. What would you like to say?
I don't know what to say. I mean, I messed up. I'm sorry to my kids and my family. It's the only thing I can really say.
Have you said everything you wanted to say?
Yeah.
Thank you. So I begin by looking at your history, and it's unbelievable to me that you have been a methamphetamine user for 25 years and you are still alive. It is mind-blowing to me that you're able to use for that long and still live. You've been to prison for methamphetamine.
Yeah.
Methamphetamine is ingrained into your life. I don't know how to get you away from methamphetamine. I offered you drug court, pleaded with you to take drug court. More than once we asked you to come into drug court and you weren't interested. So that's off the table. And when you were placed on bond, Mr. Wiles, at the charge, according to the report that you said is true and accurate, you were positive for methamphetamine 7 times and MDMA on one occasion after that. And that's during the time that you were on bond. I don't know how to treat you. And if I release you into the community today or Monday or next week, you're just going to go right back to the dope house and use drugs again. Kill yourself or hurt somebody else. That's just the reality of the situation. That's what I see. I see 17 criminal violations. I see Michigan Department of Corrections for use of meth. And I see a man that declines the offer of treatment. Having said all that, you have some financial obligations. Do we have pretrial services fees owed, Ms. Birchmeyer? Okay. Crime victims assessment in the amount of $130, court costs in the amount of $961, and a $68 state cost. As to incarceration, you will go back to the Michigan Department of Corrections where you'll spend a minimum of 15 months, not to exceed 120 months. And against that sentence, you receive credit of 110 days. Agent Raul, please include in Mr. Wiles' packet requests the Michigan Department of Corrections have Mr. Wiles undergo a substance use evaluation and have him follow those recommendations so he can get some treatment with or without his consent. You have appellate rights. Mr. Schmidt is approaching. Please initial the form acknowledging that you received the same. If you'd like court appointing counsel to assist you with an appeal, you've got 42 days from today's date to make that request. Thank you all very much.
And I'm sorry, Your Honor. I mean, just for the record, the pre-sentence investigation report does indicate he was looking for help.
Pardon me?
I'm looking, is the court explained that my client rejected any type of help. He rejected.
The record's closed, Mr. Allen. He did. We asked him if he wanted treatment. He said no.
I understand.
Thank you.
I would just note for the record that the court, PSI says different.
That the court what?
PSI says different.
PSI says different? That is not true. It can say that, but that's not true. My people asked him if he wanted treatment. I asked him if he wanted treatment. It's in the plea transcript. He said no. He wasn't interested.
The difference between drug court.
Thank you. Record's closed.